Statement of Changes to Immigration Rules, HC 1496, announced on 17th of July 2023. I understand that there are a lot of rumors circulating, so of course, it's my job, as I always do, to keep you updated with everything that is going on. So, let's get started. What is Suella Braverman up to now? Some good things and some ridiculous things. But anyway, that is always how immigration rules work here. First of all, what are the main changes? What is happening? When does it come into effect? The main thing that I've been asked about all day today, the many questions I've received are about students who wanted to bring dependents, or those students who wanted to switch onto a work category, a business immigration side of things. So those are the ones immediately affected, because the rules were announced on the 17th of July, which was yesterday, and the implementation time was 3 p.m. So they are already in effect. So if you do not qualify, or if you do not fall under those categories, then that is a missed chance. What I'm going to do now is, instead of creating a panic everywhere, you need to understand that there are certain situations that can still be managed if it is something that you wish to do. For example, if you're a student and you want to go into a work category, it can still be done. And even if you haven't completed your course, but you need to be patient and understand everything. So bear with me, because there's a lot to go through. There's 11 pages of the explanatory memorandum to the statement of changes. And I'm just going through the index, and I'm just going through all of those just to give you brief outlines of everything. So first of all, let's get started. I'm looking at the asylum, posing the differentiation policy. This is 6.3. What they've done is, if you remember, I've done a video on this before as well, where the Home Office had said, this was last year, I think it was when Priti Patel was in power. And the idea brought in at that time was that when people claim asylum, they will be put into two categories. If somebody had entered the UK illegally, then they will be put on a different category. And those who were in the country and who had claimed asylum properly would be put in a different category. And the result was in the grant of status that you were given. So if you were in the first category, where they think that you have entered illegally, then you would be given 30 months. And then after 30 months, they will reconsider your claim, see whether or not you should be allowed to stay, and then so on and so forth for the next 10 years. They were supposed to be doing that. The other thing was, if you were granted asylum straight away, and if you had not entered illegally, then you would be granted the 5-year refugee status, as people get now. What has happened now is that they have decided that that is not going to continue, and that the word used is pausing the differentiation policy. I think that's just a polite word to say we messed up. So what they've said is that that is not going to be applied any further, and that everybody right away is going to be again considered under the 5-year route. So if anybody is granted asylum, they are recognized as a refugee, they will be granted the 5-year asylum and not the 2.5 years to go on to a 10-year route. Now, going on from there, student route changes for dependents and switching. This is where people are most concerned and most worried. What's happened to that? First of all, the cutoff time was 3 p.m. on 17th of July. So this has already happened. We are on the 18th of July today. What we are talking about now is that the changes, what they say, the changes that they brought in. First of all, if you are a student and you have not completed your course, if you are in a postgraduate course or an undergraduate course, whatever it is, if you have not completed your course, you're no longer allowed to switch your category unless you are on a postgraduate route, which is currently designated as a research program. So if that is the case for you, then you're fine. Otherwise, you cannot do that any further. I'll read out the exact thing. Other changes, okay. The changes relating to student route have come into effect on the 17th of July at 3 p.m. The government considers this departure. Now, if you have been following immigration rules always, and you understand how these things work, usually whenever the new statement of immigration changes is announced, it is a 21-day period in which they are implemented. Now, what they've done now is that they wanted to make sure that people do not rush in and make applications to come within the existing laws. That is why they have done away with the 21-day convention, and immediately on the same day as it was announced at 3 p.m., they made the rules effective. So that is what's happened. So what the changes? Following changes are being made. Removing the right for international students to bring dependents unless they are on postgraduate courses currently designated as research programs. And secondly, removing the ability for international students to switch out of the student route into work routes before their studies have been completed. Now, let me clarify both of these things. First of all, as far as the dependence thing is concerned, that law has already come into force. If you are starting new courses, the courses starting from the 1st of January, these changes preserve the ability for dependents already in the UK to extend their stay. So those people who are already here need not worry about it. They can continue as they are. And for international students on taught postgraduate courses beginning before 1st January 2024 to bring dependents. So if you are starting in the autumn intake, which is the September intake, if you've got a course, if you are starting in August, September, whenever before the 1st of January, then you're all right to bring your dependents. This thing will take effect from the 1st of January 2024, where certain courses will be excluded for this. So this is what they have said. They also preserve existing exemptions for dependents of government-sponsored students and for dependent children who are born in the UK. So if you are already in the UK as a student, you have your dependents with you and you have another child, let's say that child is born in April 2024, you don't need to worry that that child is not going to get status. Of course, that child is going to get status under the rules. With the other thing is the government-sponsored students. So if different governments have sponsored their students, or the UK government has sponsored students, whichever come under that government sponsored category, they will not be affected by that and they can still bring their dependents with them. The switching instructions, the switching restrictions will ensure that students are generally not switching in country to another route until they have completed their course. Now, I've said to another route. If you look at the rules, what it is talking about is it's talking about all the appendices that are in the business immigration side of things. So whether you can get married and then switch your status, whether or not that can happen is a completely different thing. This is work related that we're talking about. The categories that they have listed out there, you cannot switch into those categories. And there is the exception for those skilled workers who are switching into a skilled worker employment, which requires degree level. Even if those students have not completed their degrees, they can switch into that category, but cannot begin their employment till the completion date. Moving on from there, those students studying towards PhDs will be able to switch after 24-month study, rather than what was the case before, which was 12 months. So that is another change that has been brought in. What they want to say is that students who come to the UK complete their studies, and then if they can qualify for a different category, they can go into that. Those students who come over then do not go ahead and complete their courses should not be allowed to do so. Now, that does not mean that if you've been offered a job halfway through your course, there is nothing you can do about it. Of course you can. But that means you leave the country and you apply from your own country and then you come back. So this is not all doom and gloom where people think, oh my God, I was studying and I still have 2 years to go in my course and I wanted to switch and I found an employer who was willing to sponsor me and now I can't switch. That is not the case. If you found an employer who wants to employ you and you wish to go into that category, then the simple thing to do is you complete your course, then do it. Or if you do not wish to complete your course, if you want to do it now, then you leave the country, go and apply for correct entry clearance. Because reading from this is my interpretation and this is my understanding of it. Reading from this is only applicable to switching applications. So this does not mean that you cannot go and apply for an entry clearance application from your own country. So that is something that we can bring in. Moving on from there now. Student route, dependence and switching, we've spoken about that. Now, changes to the EU settlement scheme. What they've said is, first of all, the validity of the applications. Right now, people make applications and then they're sent the certificate of application, and then they have given their reasons why they did not apply by the deadline of June 30th, 2021. Now what they're saying is that there's going to be two-stage process. The first process is going to be to see whether or not the reason that you've given for your delay is a valid reason. Because if they believe that the reason is not valid, then they're not even going to go on to the merits of the application or the eligibility or compatibility.